respond to my disability carrier or plan's questions or requests for more information. Now, I want you to understand that under the federal ERISA rules and regulations, a disability carrier or plan has a number of obligations. And one of them is they are required to respond to your initial application in a timely manner. So you, in turn, should respond as quickly as possible. However, is not a slapdash, get it out the door, get my homework done so I can go out and play type of approach. Your response should be complete and accurate. So, for example, if they ask you to fill out a form, you should do so carefully. And when you do it, you should be sending it back email or certified mail return receipt requested. I want you to keep a copy of it. But before you're sending it out, I want you to carefully think about the answers to those questions. I want you to let them sit a couple days and then maybe give them to a loved one or someone else to look at. You answer the question. You're not telling a story. You're not writing a book. You're answering the question. But you need to do that completely and accurately. And I always think that symptoms and functionality are a good way to think about answering the question. Now, you might be tempted to just call the claims examiner and give them the answer on the phone. Please resist that temptation, and please resist sending them an email. I promise you that the claims examiner can and most likely will twist what you say into something that's completely false if you are having a phone call. And they'll potentially do the same thing with emails. I've had that happen a lot where the adjuster will ask a question, the claimant will give an incomplete answer. And when the adjuster should follow up with a follow-up question to expand on the answer, they don't. And they don't do it on purpose because they like that incomplete answer and they can twist it and use it as a reason for denying or terminating benefits. They will create a reason to deny the claim or terminate benefits based on what you have said. And if you don't understand what happens in these phone calls or in emails, you're setting yourself up for a claim denial and termination. I never, ever let my clients communicate with a disability carrier by phone or by email. It comes through me because I understand the policy and the plan. I understand the medical records, and I understand why the carrier is asking the question and how they're going to be using your answers to set up a claims denial or termination. If you decide not to follow my advice and you speak with them, write a confirming email that is factually based. 1, 2, 3, 4. Don't fill in any stuff about this or that. I'm disabled. I hope you pay my benefits. I'm a good guy. I'm a good person. I love my family. I rely on these benefits. That does not move them a second. Doesn't move them emotionally, intellectually, isn't going to move them to pay the benefits. You should be answering the question and keeping a copy of your answer. So you want to be keeping a contemporaneous record of the discussion. Now, of course, they won't let you record the conversation. Depending on where you live, you might be able to do so without their consent, but I'm not giving you legal advice about recording conversations with disability carriers or plans. What happens if you don't timely complete or respond to the request for more information? You can count on a claims denial unless you request an extension, and they grant that extension. Be careful of the extension game that the carrier or plan will use, because they may say, look, if we don't get what you say you sent us by this date, we're going to deny your benefits. Then again, they're kind of setting you up for a claims denial. And you need to be having an exchange of correspondence with them saying, this is what I sent you. This is what you asked for. This is what I'm getting. This is how much time I need. This is how much time you got. They may play this game, well, we still need more information. And if that delay, the game is being played, it certainly is time to hire an experienced ERISA disability attorney. Remember that under the rules, they have a time to respond, but extensions can extend that time. And when do the extensions end? That could be the endless extension game, the delay game. And at that point, I think you, as I said, need an experienced ERISA disability attorney who can provide them with the correct and complete information and get a timely response from the carrier or the plan. Delay is their way of bleeding your finances, hoping that you give up. They don't have to pay the benefits you deserve. So again, the answer to a lot of these questions depend on your individual circumstances, what the policy or plan has to say, what your medical records have to say, and you're doing all this while you're dealing with your disabling medical condition, making a lot of important decisions. Applying for disability benefits, dealing with applications, dealing with delay, dealing with denial or termination really isn't what you should be doing. You should be consulting with an experienced ERISA disability attorney.